Delaware Riverkeeper Network. My name is Yeager. I am Senior Outside Counsel to the Delaware Riverkeeper Network, and I'm a partner at the law firm of Curtin Heefner. And we're going to talk today about the Environmental Rights Amendment to the Pennsylvania Constitution. So just a quick overview of the topics that we'll cover. First, I'll give a history of the Environmental Rights Amendment, a brief history from its inception to what we call the bad old days, when it wasn't respected and given meaning, to its rebirth through two cases, a case that's known as Robinson Township Delaware Riverkeeper Network et al., which was a 2013 case, and a case from 2017, the Pennsylvania Environmental Defense Foundation case, which we'll often refer to as PEDF. And then I'll spend time talking about what the standards are under the Environmental Rights Amendment. So first we start with the language itself, and the Environmental Rights Amendment is found in the Pennsylvania Constitution in Article 1, which is the Declaration of Rights section of the Constitution, and Section 27. And so it says that the people have a right to clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. And finally, as trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. All right, so this language became part of the Constitution in 1971, and like all constitutional amendments in Pennsylvania, it had to go through a rigorous process to get approved. That meant it started by requiring two sessions of the General Assembly, our state legislature, the State House and the State Senate, to approve it over two different sessions, and it was approved unanimously through the General Assembly, which is not a common event. Then it goes to the voters of Pennsylvania, and when it went to the voters of Pennsylvania, it was approved by a margin of 4-1. There were a number of ballot questions that year. One of them was adding what is now the Equal Rights Amendment to our state constitution, guaranteeing gender equality. That passed by a margin of 2-1. So this is a very high level of support for the Environmental Rights Amendment. And it really grew out. It was certainly a time in Pennsylvania and a time in the country when there was increased recognition of the harm that was being done to our environment following publishing a Silent Spring, the devastation that Pennsylvania had experienced through the difficulties with the remnants of the coal industry, with the excessive logging that had gone on in the state, with poisoned drinking water. And so there was a moment in time when this was recognized as having that highest level of importance. Pretty quickly, though, the courts really narrowed the application of the Environmental Rights Amendment. And the test that was developed that became relied on for the next couple decades is a test that came out of a case called Payne versus Kasab in 1973. And you'll see on the slide the elements of that test. But really what is important to take away is that it primarily looked to whether what was being done complied with existing statutes and regulations. And it ignored the fact that the Constitution and the constitutional rights are higher than our statutory and regulatory rights. And so it really just kind of relegated the Environmental Rights Amendment to more of a statement of policy than any kind of meaningful set of constitutional protections. That was the case for, as I said, for decades. And then starting in 2012, there was litigation that the Delaware Riverkeeper Network took the lead in, and Maya Van Rossum as the Delaware Riverkeeper, working with a group of 7 municipalities from around the state, 2 municipal officials from municipalities in the western part of Pennsylvania, and a doctor, and they brought collectively, and this was work that we were involved in, brought a constitutional challenge to a law known as Act 13 of 2012. And what Act 13 did was it established or tried to establish a set of uniform zoning provisions and broad preemption to allow the oil and gas industry to really run free rein around the Commonwealth and get to do what they wanted to do in municipalities all over the state. So to understand it just briefly, let's look at what the law was like prior to Act 13. Prior to Act 13, there was a recognition that municipalities could use their zoning authority to say where in a municipality they wanted to allow oil and gas development and where they wanted to protect from oil and gas development. And there was narrow preemption. Preemption is a concept where what the state does trumps what happens at the local level. So there was a set of narrow preemption for the operational aspects of gas drilling, what kind of casing you can use or what the size of that casing or materials ought to be. But the big picture issues about where this industrial activity could happen was left to local municipalities. The oil and gas industry didn't like that. They wanted to be able to develop everywhere and anywhere, so they were successful in getting Act 13 through. Now, when we're talking about zoning, we're talking about just the basic ways that a municipality protects its residents from harm. So in this slide, you'll see it's one of these things is not like another, or which one of these things is most like the others. And so is a gas well more like a house, more like a farm field, or more like a factory? And that's the exercise that local leaders go through when they enact their zoning ordinance. And they say, look, a gas well is more like a factory than it is like a house. So we're going to zone it to areas where we allow factories, and we're not going to put it in places where people are raising their families and are trying to live in peace and quiet. We're not going to put it in areas where we're trying to protect the soils for agricultural activity, where we're trying to protect fragile water resources. We're going to have a zone where we're going to allow industrial activity to happen and keep it away from those other fragile resources. So what Act 13 did was take away local authority to do that. It had a lot of other bad provisions, but that's the part we'll focus on for now. So it defined oil and gas operations very broadly and required every municipality in the state to change their zoning ordinances within 120 days to allow oil and gas in every zoning district. It also established broad preemption, so it said that any area of environmental regulation that was done at the state was preempted local regulation of oil and gas. So you couldn't apply your stormwater management ordinances, and you couldn't apply your other environmental protection ordinances to oil and gas activities. The legal challenge that I mentioned first went to Commonwealth Court. Commonwealth Court is one of our state intermediate appellate courts. Commonwealth Court agreed that Act 13 was unconstitutional, but rejected our arguments that it violated the Environmental Rights Amendment, and instead said it was unconstitutional because it made the zoning that was in place in all these communities irrational. It injected an incompatible use, this industrial use, in places where it wouldn't otherwise be allowed and where people had made their investments in their homes. And so it said, because it's not consistent with the planning that was done at the local levels, it made the zoning irrational. Therefore, it violated Article 1, Section 1 of the state constitution, which is a property rights protection of the state constitution. There were appeals on both sides, and it went up to the state Supreme Court. And in December of 2013, the Pennsylvania Supreme Court agreed with the Commonwealth Court that Act 13 was unconstitutional, but a plurality, most of the justices said it's unconstitutional because it violates the Environmental Rights Amendment. So a very sweeping, historic decision from the Pennsylvania Supreme Court in December 2013 that breathed life into the Environmental Rights Amendment for the first time in its history. And so you have on the screen now one of the principal quotes. It's a 160-page opinion, so there's a lot of quotes, but one that really stands out that shows that the court recognized that this is a part of our Constitution, that we have to treat it like it's a part of our Constitution, and that means that the residents of Pennsylvania have a right to rely on it, and that if the decision makers violate those rights, it's the court's role to step in and say so. And that's what the court did in that decision. Now, it was only a plurality decision, which meant that a majority of the justices on the court at the time didn't sign on to that aspect of the decision. A majority agreed that the law was unconstitutional, but they came to different reasons for why. One justice said he agreed with the reasoning of the Commonwealth Court that it made the zoning irrational, and that's why he found it unconstitutional, and the other three who said it was unconstitutional relied on the Environmental Rights Amendment. Because it was a plurality decision and because there was some change in the makeup of the Supreme Court for a variety of reasons that we won't get into, a lot of industry folks said, oh, we don't have to pay any attention to that decision because it was just a plurality. So it was very important in the summer of 2017 when the Supreme Court came out with the decision in the Pennsylvania Environmental Defense Foundation case and cemented the reasoning of the Robinson Township Delaware Riverkeeper Network decision as a majority decision. And the court was very explicit in the PEDF decision to adopt the rationale, the statement of the history of the Environmental Rights Amendment and how it should be interpreted as the law of the land in Pennsylvania. And so it cemented the ruling from the Robinson Township DRN decision from a few years earlier. PEDF involved a challenge to state forest leasing for oil and gas and what happens. There's a lot of different issues in the case, but the big issue was what happens with the money that comes out of that leasing of the state forest for oil and gas activity. Does it just get put into the general fund, or should it be used for environmental purposes and for protecting those trust assets? And we'll talk about what that means. And the court said these are public natural resources. That money needs to be put back into protecting those public natural resources. In doing that, the court was very explicit that it was overruling, throwing out that old Payne versus Kasab standard from 1973. All right, so what are the standards that govern us under the Environmental Rights Amendment? You'll see on the slides that are coming up through the rest of the presentation a lot of quotes. I've spared you the citations for those quotes, but they all come from either the Act 13 decision or the PEDF decision. So let's talk about the broad basic principles. The first is that the constitutional text matters. And this is a conservative jurisprudence notion that we look to the text of the amendment. And we are guided by what that text actually says. So the proper standard when you're asking questions about environmental rights, the starting point is the amendment itself. Part of that language that we looked at is a statement of trust, that the Commonwealth serves as a trustee over Pennsylvania's shared natural resources. And so the court said when we're thinking about those issues, we look at Pennsylvania trust law that was in effect in 1971 at the time that the amendment was enacted. The second basic principle that guides us is a recognition that Section 27, the Environmental Rights Amendment, is in Article 1. And there's a couple things that flow from that. Article 1, as I said, is the Declaration of Rights. It's like the Bill of Rights section of the Pennsylvania Constitution. And it means something that it's in that Declaration of Rights. And it means that it's a fundamental right. And it means that it serves as a limitation on government authority. And so that means that everything that the government does, whether it's the General Assembly or another branch or agency of government, is limited by the rights that are stated in the Declaration of Rights, including the Environmental Rights Amendment. So what the Constitution does generally is the Constitution is a grant of authority to government from the people. And it's the people getting together through the Constitution and saying, government, this is what we're going to allow you to do. This is what you're required to do. And here's what you're not allowed to do. That's what we do when we enact a Constitution. And so in the Declaration of Rights, for the most part, that's a reservation of rights in the people. That's the people saying, government, when you get to do everything, you don't get to do some things. And one of the things you don't get to do is mess with our ability to have a clean and healthy environment. And that's one of the core concepts that guides us as we think about the Environmental Rights Amendment. Another aspect of being in the Declaration of Rights is that that's where we find our other fundamental rights, our other core political rights. So it's where we find our free speech rights. It's where we find statement of our religious liberties. It's where we find statements of our rights to bear arms. And when we have the rights that are stated there, they all have to be thought of and handled the same way because they're all at the same level. And so just like the government can't take an action that would violate our other core fundamental political rights, the government can't take action that would violate our right to a clean and healthy environment. So just like the government can't take action that would violate your free speech rights, government can't take action that would violate your environmental rights. There's a bit of a metaphysical question here about what came first, the right or its statement in the Constitution, and the court said, it exists, this is our right. The fact that it's in the Declaration of Rights tells us that it exists, but it exists independent of that. And that's what it means when we talk about an inherent and indefeasible right. We know that it is because it's in the Declaration of Rights, but it's kind of divinely there. It's divinely there, though, through hard work of activists and friendly legislators and the citizens who got it enacted through the legislature and ratified it when it was on the ballot. And the court said, and this is from the Act 13 decision, it's not a historic accident that it's there. We can see why it's there when we look at what the environmental degradation was, what the harm that was being done to the environment. There's a reason why the citizens recognized it as so important. We talked about this notion of the government as a trustee. The courts have been clear that those trustee obligations aren't in just one branch of government. They're in all agencies and entities of the Commonwealth, both statewide and local. That means that if PennDOT is doing something, PennDOT is limited by the Environmental Rights Amendment. It means that if the Public Utility Commission is doing something, if they're purporting to grant approval for a pipeline, or they're purporting to grant approval for high power, high voltage transmission lines, they are limited in what they do by the Environmental Rights Amendment. If the legislature tries to enact a law like they did in the Act 13 case or like they did in PEDF, the legislature is limited by the Environmental Rights Amendment. And it means that all the permit decision makers, and it means that all the government officials at the local level, they all have the same obligation to respect the Constitution. They don't get to pick and choose which parts of the Constitution they like and which they don't like, which they want to respect and which they don't want to respect. And because they're trustees, they have a fiduciary duty to act toward the corpus of the trust. The corpus is the body of the trust. It's those shared natural resources. It's our air, it's our water that we all depend on, that they have to act with prudence, loyalty, and impartiality. So one of the questions that we get asked is, does this just apply to government actors? And does this just apply to what the government does? And the answer is no, because the government has a significant role in allowing pollution to happen. When anybody wants to, whether a corporation or an individual wants to do something that would cause environmental harm, they go to the government and they get a permit. They get permission from the government to do that. And so the government has to be guided by these environmental principles and by protecting our public natural resources when it allows private entities the ability to move forward with those kinds of projects. So it applies to the actions of private parties, particularly when we're talking about government approval for that action to go forward. So another question that we get asked is, what's the scope of the resources that are protected under the Environmental Rights Amendment? And the answer is that it's broad. So there have been folks who have tried to argue that it should be interpreted narrowly, that because PEDF involved state lands, it ought to be limited to the impact on state-owned property. And because the language of public natural resources, people have argued that it should only be things that are owned by the government. And the court in both the Act 13 decision and in the PEDF decision have been very clear that it's a broad interpretation for what those natural resources are, that it's not only state-owned lands, waterways, and mineral reserves, but also resources that implicate the public interest, such as ambient air, surface and groundwater, wild flora and fauna, all those things that are part of the world that we all depend on, right? The air isn't owned by any individual. The air moves from property to property. The groundwater that we all depend on ultimately, and surface water that we all depend on ultimately, those are shared public resources. And so those are all within the scope of what the Environmental Rights Amendment protects. The courts have also been clear that even though both the Act 13 case and the PEDF case were cases where there was a challenge to legislative action, that doesn't mean that the Environmental Rights Amendment only applies to limit legislative action. It also applies to all government action, legislative, permitting, everything that the executive agency does. And indeed, the courts have to respect the Environmental Rights Amendment when they're making their decisions. Another issue that's been raised is when we see the amendment, we see the word Commonwealth, right? And does that mean it's only the state? Does that mean, because in Pennsylvania we don't refer to it as the state of Pennsylvania, it's the Commonwealth of Pennsylvania. And the courts, even before the Act 13 litigation, the courts have been clear that when we're talking about the Commonwealth, we're talking about all branches and agencies of government, including local government. So there really is no room for dispute that the Constitution applies to all government actors up and down the chain, not just at the top of the chain. And when you think about it, it would be laughable to think that a local government could violate your First Amendment rights, your free speech rights, when the state government couldn't. It would be laughable to think that the local government could violate your gun rights, but the state government couldn't. And there's no basis in the constitutional text to say that environmental rights should be treated any differently. In fact, there's a recognition in the court's decision, particularly in the Act 13 litigation, that the protection of environmental and aesthetic interest is a key part of what local governments do. And that is one of the reasons why the notion of broad preemption, statewide preemption that prevents local governments from enacting environmental regulations is suspect, because you can't think about the environment in statewide general terms. We have a very diverse state. The nature of the environment, the nature of the terrain is different in southeastern PA than it is in northeastern PA, than it is in north central, south central, the middle of the state, Erie, the southwestern part of the state. These are all very different regions. So we have a very diverse state. And all around the state, those resources are different and the concerns are different. And we're dependent on our local governments to be the front line, to know their terrain better than the state does. We respect small local government in Pennsylvania. We depend on it to protect citizens' rights. And that's particularly true when we consider the environmental conditions in Pennsylvania. So the courts have been very clear that local conditions matter and the local role matters in protecting these environmental rights. We talked about the trustee duties, and one of those trustee duties is that the government act with prudence in its decision-making, and that's where this concept of science-based decision-making comes in. If you were a trustee over a pot of money, and you had responsibility for managing that pot of money, and you said, I'm going to go to the casino and put it all on red 13 and spin the wheel and see what happens, you would probably get sued by the beneficiaries of that trust, and they would say you didn't make reasoned decision-making and you weren't really thinking through your decision-making. You have to respect the environment in the same kind of way. And you can't just throw those environmental interests around without knowing what the impact is going to be of your decision-making. And so science is the guide in that. It's through science that we can determine whether there will be an impact on our environment, what the level of that impact will be. And it's only by making those assessments and studying those assessments that the government is protecting our environmental rights. And when the government, but it's not just do the study, okay? And there's a federal law called NEPA, the National Environmental Policy Act, which is a law that says before any major federal action is taken, there has to be an assessment of what the environmental impact will be in different ways depending on the nature of the project. We're saying, and what the Environmental Rights Amendment, what the courts have said is, yeah, you've got to do that study, but doing that study isn't enough. You then have to be guided by the study. and you can't take action consistent with your constitutional duties, government actors, unless you then are guided by what that science tells you. So if that science tells you that taking that action, allowing that project to go forward, enacting that ordinance or enacting that regulation, if science tells you that that's going to cause an unconstitutional level of degradation of the environment, then you can't do it. You can't pass that law. You can't enact that ordinance. You can't approve that permit. And we see that kind of thing happen regularly. That kind of system is set up where if you want to develop your property in a municipality, the municipality is going to require you in most places to submit plans that show how you're going to manage the stormwater impacts. And they're going to want to make sure that you're not causing a degradation of your neighbor's property or of a nearby stream by the stormwater that's being generated from your development project. And we require those developers to hire the experts and to present the evidence so that the government can feel comfortable in making those decisions. And it's the same thing that that government actors are required to do across the board with their decision making when that decision making poses a threat to environmental interest. And so at a local level, local governments ought to be requiring developers to come forward with that science, to come forward with those studies, to show what the impact is going to be, to demonstrate that there is not going to be an unconstitutional level of degradation of our environment. What we do at the municipal level frequently is we require developers to put money into escrow so that the municipality can hire its own consultants to review those studies and to make sure that those studies are valid. And the same thing ought to be done across the board. One of the things that industry has tried to argue is, we can't go this far with the Environmental Rights Amendment because it will shut down all economic activity. And we're not going to be able to do anything. If I throw a stone in the river, I've impacted the environment. And that's what we call a straw man. That's not what the Environmental Rights Amendment says. It's not what the courts have required. What the courts have required and what the language of the Constitution says is about degradation. And that means that it's not that you can't do any activity, it's not that you can't have any impact, but you can't degrade the people's public natural resources either now or in the future. And and governmental agencies are very used to carrying out that kind of non-degradation standard. Those standards exist and are applied regularly as part of the government approval process in certain contexts. For example, if you've got what's called an exceptional value stream, there's a non-degradation standard that's recognized as state law that you can't engage in an activity that would degrade the water quality of that stream. And that's what is required across the board with the protection of our public natural resources. And getting to the end of the presentation, of course, all the things that I'd be talking about would be meaningless unless the citizens could enforce those rights. And so that means that just like in the Act 13 case and just like in the PEDF case, when the government has gone too far, when it has violated the residents' environmental rights, the residents have the ability to hold government accountable for that. That's part of what our democratic process requires. And so the residents have the ability to step up and speak out and require the courts and require those agencies to enforce those environmental rights. So we just come back around for everybody's reference to the text of the amendment itself and remind us all that when we have questions about whether our environmental rights are protected or not, or whether they've been violated, the starting point is to go back to this text and to make sure that this language and our rights are being honored. And we'll leave it there for now. So if we have questions, we can do questions. Yes.
So how is the language pure water, clean air defined? How do we figure that out to know when there's been an overstep, a violation of somebody's right to clean water, for example?
I mean, we do it the same way we answer that question with the EV standards, the exceptional value standards that I was talking about before. As part of environmental decision making, the Department of Environmental Protection and other government agencies are able to say, look, this is what the existing water quality standards are. This is what the standards are for healthy waters. And nothing should be done that would take us anywhere below those standards for healthy waters. And that's easy to measure, and it's done all the time. Yeah.
I'm kind of wondering, I guess, because the 2013 decision and the PEDF decision brought new power into the Environmental Rights Amendment. How do you think government agencies now have to start incorporating new tests into the permitting process, or how are they going to start, I guess, adding those protections?
Right. Well, I mean, it's going to be an ongoing struggle for advocates to insist that the government agencies do that and that they do it well. They have the tools to do it because they do it in narrow context now, and it's a matter of advocating and getting them to apply those tools in a broader set of context. But we should expect that there are costs associated with that, and whenever there are costs associated with it, look, our Department of Environmental Protection has had its budget starved, right? And there's been a lot of slashing of Department of Environmental Protection's ability to do its job. So we need to make sure that they are adequately funded so that they can do the job, because it takes more than a check-off-the-box kind of permit review. It takes actually digging and making sure that those environmental rights are protected. And if the agency doesn't have the people power to do that, it's not going to happen. So we need to make sure that that's happening. And then it's broader community education, right? The more people are empowered to understand their rights, the more they can speak up when they think more could be done to protect their rights. And there's a lot of local governments that are trying to do the right thing. There's a lot of folks at the state level who are trying to do the right thing. But there are going to be times when that's not happening, and it's up to the people to remind their government actors that these environmental rights exist, they matter, and they need to be honored the same way others do. Other questions?
Have you seen the Environmental Rights Amendment used by individuals to sue the government in a private cause of action to assert that because of pollution, the government allowed through the issuance of a permit that people lost property values or their health was impacted, and therefore the government should give them payment in order to make them whole because of that personal damage they suffered?
Not in Pennsylvania. The Pennsylvania, and again, we're applying general constitutional principles. So we have a whole body of constitutional law that we can already look to answer a lot of these questions. And that kind of question has been answered in other contexts in constitutional law in Pennsylvania, that people don't have the ability to sue the government for monetary damages under the Pennsylvania Constitution for a violation of their constitutional rights. And it's a reminder that sometimes constitutional law, like all areas of law, it takes a long time to get developed, but we have that body of law to look back on. And that's one of the questions that we hear a lot is there's a lot of uncertainty. You know, these are new decisions. There's a lot of uncertainty. The courts and the agencies are equipped to apply constitutional standards and to do what judges do all the time, which is interpret text and make decisions based on the facts that are in front of them. And the courts have the ability to do that, relying on those long-established constitutional principles in the environmental realm, just like in other realms. Yes?
Just because you're talking about projects and like how different Pennsylvania is, so if a company is like trying to do a project or an industry that is happening in multiple parts of, let's use Pennsylvania, does that mean then for each different part they're going to have to do the different scientific review and all that because it's affecting different communities in different ways.
Sure, and that's part of environmental review now, and it's just an added level of rigor to that. But yeah, if you want to build a highway project or you want to build a pipeline project, like what we call a linear project, right, where it stretches over a long area, you're going to have to look at the environmental impact all along the way. Absolutely. Other questions?
How does the use of this generation versus future generations get balanced in this environmental rights?
So the question about the generational impact of projects is built into the Constitution, and there's a recognition that the decision-making should not be simply short-term, that we have to look at the long-term impacts of what's being done. And you have the language on the screen now, the resources are common property of all people, including generations yet to come. So that's what tells us that we can't just look at our short-term impacts. When we think about the trust principles, one of the trust principles that we talked about is the duty of impartiality. And applying that trust principle in the context that your question raises means that they're all supposed to be treated equitably. So we can't sacrifice our future generations for the benefit of something up front, and likewise, we can't just stack all of our harm up front. We have to treat current generations equitably too. So it should be a balance. Yes?
So if you have a community that's suffering from contaminated drinking water because the government allowed action in the past, do you think that they would be able to bring an action against the Pennsylvania government that would require restoration of the water quality, even if it meant that they would bankrupt the Pennsylvania government?
Well, it's hard to get into any specific facts too deeply, but certainly the duty to remedy is part of the trustee's duty. If the trustee, the government, has allowed bad stuff to happen, the courts have looked at, as a trustee, that obligation includes a duty to remedy. Now, you've got to balance, like with all government decision-making, the courts have looked toward balancing competing interests, but there has not been a recognition of a constitutional right to economic interest. So those are fundamental duties of government, is to carry out their constitutional obligations. I think that's part of what we expect of our government is to meet its constitutional obligations first.
Can I ask a follow-up question?
Sure.
So because this Environmental Rights Amendment was given legal life in 2013, you said, does that mean if the government allowed action or activity that polluted the water or polluted the air in ways that are seen to overstep and violate the environmental rights of people, that there would still be this duty to remedy the harm that's been inflicted, even though it happened before 2013
Yeah.
or maybe happened before even 1971?
Yeah, it's not a new right. It's a right that is inherent and indefeasible. It's a right that we've always had. And certainly the 2013 decision and the 2017 decision from the Pennsylvania Supreme Court didn't create new rights. They just provided a recognition of the right way that they should be interpreted. So no, those rights have existed from time immemorial. Any other questions?
So the cases that you talked about, I think you kind of answered this, but the cases you talked about were both cases involving drilling and fracking. Do you see this Environmental Rights Amendment legitimately being used in other contexts?
Oh, absolutely. Absolutely. I mean, that was just the kind of moment in time that we were when those two cases were brought. And it was, and at that moment in time, those were the types of issues that were the types of industries that were threatening probably more than had been before, and that were getting a lot of attention, and where the government seemed to be bending over backwards to facilitate some of that. So that's what prompted it. But there's nothing in the Environmental Rights Amendment that in any way limits us to environmental rights that are only related to one industry or another. These are rights that apply across the board. Yes.
So since that 2013 case, have there been other cases or decisions or things that have happened as a result of this Environmental Rights Amendment?
Yes. I'm glad you asked. Okay. So the question is whether there have been other instances in which the Environmental Rights Amendment has been utilized since these decisions. And there's been cases that have been in the works for a long time, some of which kind of started before these decisions, and some of which have started more recently, where activists, advocates have been trying to vindicate their environmental rights, and it applies across the board. The Delaware Riverkeeper Network was involved in a case around the land application of sewage sludge in Northampton County, and relied on the Environmental Rights Amendment in protecting the river and its tributaries and the community that was being threatened by that activity, and relied on the Environmental Rights Amendment in doing that. The pipeline battles that have been going on, Mariner East, Atlantic Sunrise, Penn East, and certainly there have been legal challenges that have raised environmental rights issues in those cases. There are landfill cases, there are CAFO cases, there are cases with historic, the Bishop Tube site, a long polluted site where the issues are being raised, where the department has allowed that pollution to go on and has been cooperating with the developer over that site. Again, Delaware Riverkeeper Network has been involved there in trying to enforce the people's environmental rights, relying on Section 27.
Do you think that the Environmental Rights Amendment, in addition to the litigation where it's being raised and the successes there, do you think it's starting to impact the way Pennsylvania government is engaged in decision-making and lawmaking?
Yes and no. I mean, I think at the level where community members are able to be easily engaged, like at the local level, community members are raising these issues with their local governments, and it's impacting what happens at the local level. I don't think there's any question about that. And that's happening all over the state. At the state level, I think it's impacting what the State Department of Environmental Protection is doing. I think obviously there's more room for improvement there, and there's advocacy going on constantly to try to get DEP to apply these constitutional standards more rigorously. With regard to what's happening in the legislature, I think that the higher, and this is one of the benefits of local government, but I think the higher up you get with government, the harder it is for residents' voices to be heard, and you tend to see industry voices heard more loudly because of the economic power that they tend to have and their ability to pay lobbyists and get their message out. So I think there's less sense of it seeping in at the state legislative level, but it's certainly being raised.
So you, as the lead attorney that really secured the decision that breathed life into the Environmental Rights Amendment and has been on the forefront of so much of this work here in the Commonwealth of Pennsylvania, do you see benefits from this success for other states in the nation?
Absolutely. Every state in the nation has its own constitution. There is only a handful around the nation that have any provisions in their constitutions that address environmental interests. There's really only one or two others, Montana being notable among them, that have anything close to what Pennsylvania has. But Delaware River Keeper Network, through its For the Generations project, has been taking a lead in, and Maya Van Rossum, the Delaware River Keeper, has written a book about the value of green amendments, and people around the country, as they hear about it, recognize immediately the value of it. It is intuitive that our right to be on our, be outside, whether it's on our own property or in a park or walking down the street, that our right to breathe clean air is as much of a value and is as important to us as our other core political rights. And we need that recognized at the highest level, and that's through our constitutions, both our state constitutions and ultimately our federal constitutions. And there is, I think, a psychological benefit to starting to recognize that importance. And so the more this discussion happens around the country, the more people start to recognize it, the more then they act like it, and the more they demand that their government officials act like it. So simply having the discussion adds value. But then actually building it into the Constitution, for all the things that we've talked about in Pennsylvania, look, some very bad laws got struck down that would not have been struck down in Pennsylvania but for the environmental rights amendment. And so it is a very important tool for residents to hold government accountable when government allows that kind of bad stuff to happen to them.
Can you give examples or maybe like what you think it would mean for other states, like places like Flint who have like a water crisis now, how if they had this in their state, they would now be able to bring action against environmental harm that's already been done to them?
Sure. I mean, when you've got when you don't have an environmental rights amendment, what you're left with is are state laws and federal laws that are very narrowly drawn. And that generally have very limited opportunities, strict time limits, for example, and very limited opportunities to prevent harm from happening even in the first place. And so the first thing that I would say is that it is an important tool to prevent the harm from happening in the first place, because it requires more of government to prevent that bad stuff from happening. And when it does, it's not enough for somebody to say, well, we had all the proper permits when we did it. That having those permits isn't enough. That our constitutional rights are above those permitting regimes. Our constitutional rights are at the highest level of protection. And if you've allowed environmental harm to occur, that's at the level where people can't drink the water anymore, and people can't live a healthy life. That's at the core of what we expect of our government. And if the government falls down on that, we need a tool to be able to hold them accountable, and constitutional rights provide that. Yeah.
What happens to arguments where the government says it has a limited pot of resources and can't respond fast enough? If they're not responding quickly enough to issues that require remediation or issues in which streams are being degraded, have they violated a constitutional obligation?
Just the thought process that I always go through is I would try to translate those kinds of questions into other realms of constitutional rights and ask how we would tolerate those kinds of situations if we were talking about our other constitutional rights. So like thinking about it in the free speech context. One of the principles of First Amendment law and free speech law is that you have a right to protest, right? You have a right to be in the street. And one of the things that go with that is that the government can't issue a permit to another group. If you've arranged for yourself to have your demonstration in the county park on July 4th, the government can't then issue a permit to the group at counter demonstration in the same place in a way that would drown out your voice. And that's part of how you protect the free speech rights of of a group to assemble, is so you don't allow that heckler's veto. And that's an obligation on government to not allow the hecklers to interfere with the free speech rights of other residents. You have to balance those competing interests. We would never say to anyone that those free speech rights are, we can't honor them today because we don't have the economic resources to prevent this other crowd to come and shut you down. We wouldn't tolerate that. Why should we tolerate that when we're talking about these constitutional rights? I think we're done with our questions for today, so thank you. And if folks have more questions, of course, the contact information for the Delaware Riverkeeper Network is available through the webinar. Thank you.